I've been working a lot lately with clients on getting errors and omissions, or E&O insurance, for their indie films. Often this is an issue that comes up for the first time when a filmmaker signs a distribution deal. When you get a draft distribution contract, you're going to get a long and often scarily long list of deliverables from the distributor, which is going to include a requirement that you get E&O insurance coverage. And then you go to an insurance broker to ask about E&O insurance, and they come back with another scarily long questionnaire asking you for information about your film and your production company. Some of the items on that questionnaire might be things you didn't expect, like whether you have a license to show every video clip or photo that appears in your film, and this is particularly important if you're doing a documentary. And if you don't have a license for every clip or photo, you may need to have an attorney write a letter saying why your use of the clips is fair use for copyright purposes. The best time to be aware of these E&O coverage requirements is before you start shooting your film, so you're not blindsided by these requirements when it comes time to distribute your film, and you have to potentially deal with a lot of expenses that you didn't budget for. So I'm going to talk about those requirements in this video, and I'm going to use an E&O insurance questionnaire put out by Hiscox Insurance, which is pretty much the industry standard for what you're going to see as a guide to understanding those requirements. But first, a couple of disclaimers. First, this is not legal advice, because if I were going to be giving you legal advice, I would need to understand your specific situation and needs, and right now I'm just a random lawyer talking to you on the internet. Second, I'm going to be talking about matters of U.S. law. So if you're making your film outside the United States or your production company's outside the United States, then the legal concepts that I talk about in this video might not apply to you. Finally, if you find this video helpful, please like this video and subscribe to this channel so I can keep providing this kind of content for young, hungry, up-and-coming independent filmmakers such as yourself. Anyway, let's get into it. So getting back to the requirements for getting E&O insurance. Let's start with a basic question. What is E&O insurance, in case you haven't heard of it before? Like I said, it stands for Errors and Omissions Insurance, which covers a production company against a couple of different types of litigation, that is, lawsuits in court. The first main category is lawsuits for intellectual property infringement, so infringements of copyrights and trademarks. If you use, for instance, a copyrighted news clip without the permission of the news channel, and you get sued by the channel for copyright infringement, your E&O insurance is supposed to cover your defense of that kind of lawsuit. The second category is essentially lawsuits for defamation and for invasion of privacy. Defamation means a false statement about someone that's harmful to their reputation. Let's say that you make a true crime documentary film and your narrator says that Joe Johnson probably committed the unsolved murder that you're talking about. Then Mr. Johnson sues you, claiming that your film's statement about him was false and harmful to his reputation. That's a defamation lawsuit. To get this kind of insurance, like I said, you're going to have to complete a questionnaire. Let's talk about the questions that are likely to appear in it, which tend to be basically the same no matter what broker or what insurer you want to use. Let's look at a typical example. This is a publicly available document, which is the Video, Film, and Television Producers Application used by Hiscox Insurance Company. The questionnaire starts by asking you the insurance policy limits you're looking for. In other words, how much of the cost relating to one of these types of lawsuits I talked about, the insurer is going to have to pay. The important issues here are the length of the policy limit per claim, the aggregate policy limit, and the retention or the deductible. What does each of those things mean? The length or the term of the policy just means the period of time for which the insurer is going to cover you for the types of litigation that we talked about. Often your distributor is going to want the insurance policy to last for the length of the distribution agreement. That is the period of time for which the distributor is going to be distributing your movie, which will be stated in your contract with the distributor. The limit per claim means the maximum amount the insurer is going to have to pay out for each actual or threatened lawsuit against you. And that's for both the amount of money that you have to pay to defend the lawsuit, that is your legal fees, and any damages that the court might award against you, or any money that you might pay to settle the lawsuit. So if your policy's limit per claim is $3 million, and someone successfully sues you for copyright infringement and gets a judgment against you for $4 million, your insurer is going to pay $3 million of that judgment, and then you'll be on the hook for the remaining $1 million. This calculation, of course, doesn't include attorney's fees and court costs. Don't let me freak you out with this example. I'm not saying it's likely that someone's going to be able to sue you for copyright infringement based on your indie film and get $3 million. I'm just trying to explain what these policy limits mean. Anyway, the aggregate limit means the maximum amount that the insurer is going to pay for all actual and threatened lawsuits over some period of time, which is usually a year. So if your policy's aggregate limit is $5 million and two different people successfully sue you for $3 million each, your insurer is going to pay a total of $5 million. And then again, you're going to be on the hook for $1 million. Your insurance premium, that is the amount that you have to pay to get coverage, will depend to some extent on the term, that is the length of the policy, and the policy limits that you're asking for. Finally, there's the deductible, or also known as the retention. This is the amount that you're going to have to pay out of your own pocket before the insurer is going to start paying for a particular claim. So if the deductible is $25,000 and someone sues you for copyright infringement, you'll have to pay the first $25,000 of your legal fees before the insurer is going to start reimbursing you. How do you know what terms of E&O insurance coverage you should get? In most cases, your distributor is going to tell you in the contract you signed with them. The contract will also say that you have to name the distributor as one of the insured. In other words, the insurer needs to cover the distributor as well as your production company for any lawsuits that might be filed against you based on your film. So usually, at least, you don't have to worry about figuring out the terms of the policy yourself. The next piece of information you should know in advance that you're going to have to provide to your insurer is whether the name or likeness of an actual person is used in the film, and if so, whether you have an agreement that allows you to use that person's name and likeness. What does this mean? If you use a video or photo of someone in your film without their permission, under the law of some states, they may be able to sue you, with some exceptions. For instance, if they were in a public place when you photographed them. The insurer wants to know if you did this to decide on the premium that they want to charge you, or whether they want to exclude certain types of coverage from your policy. Knowing this in advance, that is, knowing that using someone's name or likeness without permission can affect the terms of your insurance coverage, can help you to make decisions about how you want to shoot the film, and it can motivate you to make sure that, if possible, everyone who appears in your film has signed a release that says that you can use their name and likeness in the picture. The next thing the insurer will probably ask you about is a title report. What is a title report? It's a report about whether other creative works, that is, other movies, books, songs, and so on, have used the title of your film. The vendor who you hire to perform the title report searches a bunch of databases, that is, the U.S. Copyright Office, the U.S. Patent and Trademark Office, IMDb, the Library of Congress, etc., to see if your film or a similar title has been used. Getting a title report is probably going to cost you around $400. If you don't get a title report, the insurer may want to include what's called a title exclusion in your insurance policy, which means that the insurer is not going to pay any claims relating to the title of your film. Your distributor might be unhappy with that, although it depends based on the distributor that you're working with. And so they might require you to get a title report done to remove the title exclusion. Next, the insurer will probably ask you about the so-called chain of title of your film and whether there's any kind of lack of clarity surrounding it. I've talked in a bunch of other videos on this channel about what the chain of title means, but just to give you a brief summary, it basically means the documents that show who owns the IP or the intellectual property relating to the film. For instance, if a screenwriter writes a script, they own the copyright in that script, and no one else can use that script to make a film unless the screenwriter gives them permission to do that. If a writer sends a script to you and says, go make a movie using this, but you don't sign any kind of agreement with him, making clear that he's assigning you the right to use the script to make a film, that creates an ambiguity in the chain of title. That is, it's not clear from the documents relating to the film who owns the right to make a film based on the script. And I've seen this happen, even with movies that people have spent 6 or 7 figures on. If there's ambiguity in the chain of title, that creates risk for you and for the distributor and for the insurer. Suppose that your screenwriter gave you a script without charging you anything for it, and at the time they think, oh, I'm not going to make any money on this script anyway, so I might as well give this to someone hoping that they'll do something with it and get me some exposure. If your film actually ends up making a lot of money down the line, and your writer is not particularly ethical, they might come back and say, wait a second, I never gave you the right to use my script to make that film. We never signed a license agreement. And then they'll threaten to sue if you don't pay them some money. So you want to make sure that the legal documentation surrounding your film makes clear that you, the production company, have all the rights you need to make the film. This helps avoid difficulties getting E&O insurance and other legal problems down the line. The next question that we see in this questionnaire is, even if you do clearly have the right to make a film based on the script for your movie, has anyone submitted material to you that's similar to your movie? In other words, if you have a production company, you probably have people sending you scripts from time to time, hoping that you'll finance and or produce their films. It's nice to have a steady stream of scripts coming your way, unless they're really bad scripts, but that can create some potential legal pitfalls. If someone sends you a script that ends up being similar to a movie that you make later on, there's a risk that they'll claim that you copied their script to make your film and that you owe them money for copyright infringement. Lawsuits trying to cash in on big movies in this way are actually fairly common. For example, there was a writer who wrote a script called Bats and Butterflies. He claimed that he gave a copy of the script to the actor Billy Zane, and Zane told him that he gave it to James Cameron. Then the writer claimed that the movie Avatar was so similar to his Bats and Butterflies script that James Cameron must have read the script for Bats and Butterflies and basically copied it to make his movie. The writer's lawsuit was not successful, but it's an example of the kind of legal risks that face practically anyone who makes a popular film or runs a well-known production company. One way to nip this kind of problem in the bud is to have people who send you scripts sign agreements that waive their right to sue based on your production of a film that ends up being similar to the content of their script. Not so that you can steal their material, of course, but so that they can't come back and falsely claim that you did. The next thing this insurance application asks is whether the writer you're working with has warranted, that is, has promised, that his script doesn't infringe the rights of any third party, and whether he's agreed to indemnify you for any breach of that promise or that warranty. What does this mean? They're asking if you have a provision in the contract with your writer in which the writer promises that his script doesn't infringe anyone's copyright or violate their rights in any other way, for instance, by defaming them, that is, making a false statement about them that damages their reputation, like we talked about earlier. The indemnification language means that they want you to have the writer promise that if someone does sue you, claiming that the script that you made your movie with violated the plaintiff's copyright or harmed them in some other way, the writer will pay for your legal fees or for any money that you may be required to pay by the court. The thinking behind this is that if the writer is required to pay for any claim against you or against the distributor based on the contents of the writer's script, the insurer is not going to have to pay those costs. The next relevant question that we see is, have you obtained a written agreement from all performers or persons appearing in your production consenting to their appearance? We talked about that when we discussed the need for your production company to, if possible, have a name and likeness release in the contract of anyone who appears in your film, whether they're a cast member or a crew member or someone you're interviewing on the street or whatever. Next, this questionnaire asks if any copyrighted video clips or photos are used in your film. If so, it asks, did you get a license to use those clips or photos? But notice that it doesn't just ask that. It asks if you got a license to use the name or likeness of anyone who appears in those clips or photos. So, for example, if you use a news broadcast clip in your documentary, this questionnaire is asking you not only whether you have permission to use the clip from the news channel, but whether you have permission to show the images of all the people who appeared in that news clip. In other words, did you get a license to use their name, image, or likeness, like we were talking about earlier? If you don't have those permissions, you may have to explain to the insurer why you believe that your use of the video clips or the photos is fair use and thus not subject to copyright liability. And in fact, you'll probably have to get a lawyer to write that type of letter for you to the insurance company. I've talked a lot about fair use in other videos on this channel, but I'll say briefly that you're significantly more likely to be able to benefit from the fair use doctrine if you're making a documentary as opposed to a feature film. This is because in a documentary, usually the copyrighted video clips and photos that are shown are used to give context to the interviews in the film. In other words, when an interview subject is talking, the standard technique in documentaries is to cut to footage that's relevant to what the interviewee is talking about. If it's a baseball historian talking about a classic game, for instance, you might cut to footage of the baseball game he's talking about as the audio from the interview plays. Under the fair use doctrine, if you give a clip or a photo a meaning or context that it didn't originally have, that makes your use of the clip or photo quote-unquote transformative, which works in your favor for fair use purposes. So the basic documentary film technique I talked about when it incorporates copyrighted footage is typically considered fair use. Of course, it's always better to get a license for every clip or photo that you use in your film, but if you can't, you're better off using it in the context of a documentary than a narrative film or a work of fiction. The questionnaire then asks if you've obtained all the necessary rights to use the music that appears in your film. You'll be expected to have a written license to use every piece of music, even music that you didn't originally pay to use. For instance, if an independent artist gives you permission to use their song in your film and just does it for the exposure. Generally, it's more difficult to claim that your use of copyrighted music is fair use, unless the purpose of your film is specifically to comment on the music that's playing. For instance, if you're doing a documentary about a particular songwriter and you're talking about their process of songwriting or recording of something of that nature. That's, again, a transformative use of the music clip because it gives a new meaning or context to the clip that's being played. But just using a copyrighted piece of music in the background of your narrative film is not likely to be fair use. You'll then be asked if you've made any attempts to obtain a license to use copyrighted material in your film, whether video or audio, and been turned down. This is important because if a copyright holder has turned down your request for permission to use their work, that, in the insurer's mind, is going to increase the risk that they're going to come back and sue you if they find out that you did use their copyrighted work anyway. And that in turn increases the risk that the insurer is going to have to pay out some money. Finally, we have this request for supplemental information. As you can see, it asks for title and trademark reports. That's the language here that's important from a legal perspective. We already talked about what a title report is. Usually you don't need to get a trademark report that's separate from the title report because if you get a title report prepared by a vendor, the report is going to talk about whether there are any trademark words or phrases out there that are similar to the title of your film. So those are the issues that are presented by an E&O insurance application that I think it's important to think about early in the pre-production or production phases of your film, so you don't have to scramble and pay a lot of extra money to meet these requirements when it comes time to distribute your film. I hope this was helpful. If you have any questions about E&O insurance coverage that I didn't cover in this video, then please feel free to put them in the comments section. And thank you for watching.